made sure to stock up.
Nice.
We've still got some in the freezer if you want.
Oh, wow. Don't say that to Cliff.
Same WhatsApp group.
Don't
You
say
and
that to
I.
Cliff.
You and I. Do you see why we've got such a good friendship?
Oh, wow.
Because Jenna loves hot cross buns. I love hot cross buns.
That's
It's hot
what-
cross buns or nothing.
That's what makes a friendship.
A friendship. Yeah. That's the foundation of a good friendship.
Yeah.
Okay, let's get into this conversation for today. We're chatting all things regarding the CCMA, how it works, how it operates, what you need, everything you need to know, or at least we're going to try and give you what you need within the next couple of minutes. Jenna, let's start with what is the responsibility of the CCMA and who are they?
Okay, so CCMA stands for the Commission for Conciliation, Mediation and Arbitration, okay? They are an independent body that seek to resolve workplace disputes between employers and employees.
Mm-hmm. Okay. Now, when it comes to the CCMA, right, what type of matters should we take to the CCMA?
Okay, so there's quite a wide range of scope that the CCMA has jurisdiction over. It could be your misconduct, it could be your incapacity, it could be your retrenchment, but the CCMA will not have jurisdiction if your industry is governed by a bargaining council. So it's very important to know what industry you work at and to seek advice if you're unsure. They also won't have jurisdiction over matters where the dispute is between an so-called employer or company and what is called an independent contractor or someone who is not an employee.
Okay. Right. So what is a 7.11 form?
Okay, so we sort of call it the 711 form. It does confuse people, all the numbers, but the forms do run consecutively. The 711 form is the referral form that an aggrieved party will complete. They have to complete it and sign it and show that to the CCMA that they've duly served it onto the, the employer or the party that's been doing something wrong, as well as on the CCMA's server. So you can do that personally or via email. What needs to appear on this form is usually all the details of both parties, very important, address, contact numbers, email addresses, the nature of the dispute as well, so that the CCMA is aware of what's happening.
Yeah.
And it needs to include potentially the date of dismissal, so that we know if your form has been filled in the right time frame.
And speaking about time frame, I mean, is there like a deadline? So let's say there's a dispute that happens today. Today's the 5th of April, right? What did the time frame look like in terms of me even lodging a complaint with the CCMA? Should my dispute be within the parameters that they have jurisdiction over?
Yes, so this will depend on what type of matter you are wanting to refer. A unfair dismissal matter, and this could be for the misconduct, poor performance, retrenchment, you only have 30 calendar days in which to do that referral.
Okay.
If you are dealing with something to do with unfair labor practice, which we've discussed before, you only have 90 days in which to do that referral. And if it's something even more serious like discrimination, you have 6 months in which to do that referral. There are times where people miss the deadlines, and you can apply for what we call condonation, but you have to have very good reasons and grounds for applying for this. And the CCMA and the commissioners will decide whether or not you've reached that threshold and decide whether or not they will grant it.
Sure.
Jenna,
Okay.
is it important that one needs to be a part of a union when going with a dispute?
No, not at all. You can represent yourself at the CCMA. It's a free service. Commissioners do tend to help employees with the law as they go along. But it's also important to note that legal representation is not really allowed at every stage of your dispute as well. And employers also get representation through attorneys, employers' organizations, and the like.
Yeah. Okay. If you have any questions, pop us a WhatsApp right now on 081 729 1657, and we are happy to throw them at Jenna, and hopefully she'll be able to answer all of your questions. If not, knowing Jenna, she'll come back with the answer at some point, knowing her. Okay, now there's differences between conciliation, con-arb, and arbitration, and all of these are important to understand and to know when going to the CCMA. Firstly, what are these differences, and why should we know what they are?
Okay, so it's important to know that the matter will generally be set down first either for conciliation or what we call con-arb, which is a joint process. So let's
Okay.
explain them each by as we go along. So conciliation is a very informal process. This is where the commission is going to sit around at a round table with both parties and try to settle the matter. We're going to try and mediate this,
Yeah.
to come to a nice solution for everyone. Con-arb is a bit of a tricky one. It doesn't apply in all cases, but where it does apply, it means arbitration is running immediately after conciliation fails. So if we're unable to settle now, we're not even taking a break, we're going straight into arbitration. That's
Okay.
not preferable, and you more likely want to have a different commissioner doing your arbitration. Arbitration, on the other hand, is a formal process. This is where you come with your bundles of evidence, you come with witnesses, you're going to cross-examine the other party's witnesses, you're going to lead your evidence, and you'll have an opportunity to do a closing statement.
Sure.
The award made by the commissioner is binding and final.
Okay. Wow. You're hectic, Commissioner.
Intense.
I'm not gonna lie. Okay, not that this is a fun process for people, but being in the arbitration side of things sounds a bit fun. It sounds like I was just thinking about it. Maybe it's because I watched them in the series, but like representing yourself, cross-examining people. Did you or did you not say on this? You know what I'm
Look,
saying?
we're not watching a law program on TV. Unfortunately, there's going to be a lot of objections and the commissioners
Yeah.
won't give you as much leeway.
Okay.
And often I've seen people blow up their own cases by not coming prepared properly.
I hear you. Okay. So what happens if you sign a settlement or an agreement or the employer fails to pay you as per the
Yeah.
settlement agreement? What happens in that sense?
Sure, so let's take it back. So you could reach a settlement at any stage during your process at the CCMA, either at conciliation, during
Yeah.
con-arb, even sometimes at the end of arbitration when parties see it might not be going in their favor, they try and at the last minute do a little settlement so that we don't have to get that final and binding award. So settlements can be made an order of court.
Yeah.
And if that happens, you can go to the labor court and have actually the first step would be to fill out a 718 form, which is a writ of execution through the CCMA. You take that to the labor court and the sheriff will be able to go off to the employer, take that with him, and they'll start attaching all the movable properties to be sold so that the employee can get the monies owing to them.
Nice, man.
I know of a friend that went through all of that, and it came to the point where there was sexual misconduct from the owner's side, and as the female, she was very worried that this would be on her record when applying for another job. Does that happen?
It depends on how far along her matter got to, because conciliation is private and confidential, but arbitration can be made a public record. You'll have a case number, and anyone can go and ask for a copy of that award. So that's a public document. So it just sort of depends on how far along she was with her matter. Settlements are also confidential, so
Okay.
yes, that
That's-
wouldn't be a public.
That's good to
record.
know. So I mean, that's one issue that Michaela is raising. What are some of the other challenges that public individuals are experiencing when it comes to the CCMA?
We are seeing a huge amount of referrals being made to the CCMA. The CCMA currently cannot cope with the amount of referrals that they are receiving. This has been made worse by the fact that in this financial year, the CCMA has received a budget cut of 100 million rand.
Right.
And I have recently experienced this with some of my own matters for my clients, where the commissioner is only available 2 days per month. And, where it's a very complex matter and we've got 20 lever arch files of evidence,
Sure.
this could drag on for over a year because they just don't have the capacity to assist. So we're seeing that parties who have the means are being encouraged to go the private arbitration route. So in other words, remove the matter from the realm of the CCMA just to get a resolution.
Sure. But I mean,
That is more costly.
yeah, I was about to ask, isn't that then costly and
It's very costly because the CCMA process is free.
yeah.
You'll obviously be paying, maybe your union fees or the employer's organization fees or attorney fees, but that is much lower than having to go through private arbitration where you now need maybe a retired judge or a senior advocate to preside over the matter, and that has to come out of the party's own pockets.
Hectic.
Sure. Okay. Also, just the last question: is a company allowed to say, "Listen, we are not going to hire you because of you took your previous employer to the CCMA"?
Yeah, like this record of it.
Yeah.
based.
Look, there are people who have a record of being regulars at the CCMA because if you go into the system and punch someone's ID number in, all of their previous matters will, appear. So that can be an issue. But I've also seen clients of mine go into interviews proud and they say exactly what happened and they get hired in senior positions because they're able to justify what had gone wrong in the previous role.
Yeah. Okay. And then if anyone needs to contact you for any sort of labor law, any assistance, especially when it comes to CCMA matters, because, this in itself can become quite complex and quite a daunting task because you don't want to rock up without the information, without the documents, without the correct things, and you've wasted an entire day. So if anyone needs to contact you for any particular reason regarding labor law, how do they do that?
Sure, thank you. So my firm is easily accessible online, Adams & Associates. Alternatively, my email address is jenna@adamslegal.co.za and our number will be 081 396 7190.
Thank you so much, Jenna. Thank you so much. And of course, we'll see each other again next month.
Yes, with hot cross buns from the freezer.
I'm serious though. Are you going to bring your hot cross buns?
I'll bring it for
Because
you.
apparently if you freeze it, then it's still fresh.
Well, let's hope there's no load shedding.
Laat ons bid. Okay. Jenna, thank you so much. It's always a pleasure and delight having you. And of course, you can catch this full conversation out on Facebook as well. And we are live on Facebook, so go ahead and catch it in case you missed it. Alternatively, we are putting this up onto podcast as well, in case you want to go ahead and check it out on